Dear students, today we are going to discuss about the TRIPS agreement and Doha Declaration or Doha Declaration on Public Health specifically. And this is the last lecture on the series of the TRIPS agreements. And what is this Doha Declaration and why it is important and what it provides for, what are the provisions and what are the leeways or what are the concessions which are granted by the to the WTO members by the WTO General Council itself, and what was the decision, and we are going to discuss and what is its implications of the Doha Declaration on public health, and then what happened after 2001 Doha Declaration. So, as I told you that our focus of this class is on the Doha Declaration. And what happened very recently after the pandemic? So, the pandemic also has made a lot of problems to the various sectors and the lockdown, and more importantly the health sector was affected. The services in the health sector was affected mainly due to the closure or the temporary lockdown of the companies, and there were a whole lot of discussion with regard to how to deal with a pandemic like COVID-19. So, the discussion what is happened in 2001, once again the same discussions came up. So, how you are going to deal with the pandemic? So, whether it is pandemic like AIDS, or it is tuberculosis, or it is COVID, and all these are on similar nature. So, there was severe disruptions in the supply of medicines and essential services. So, the problem was the people, the countries, those who doesn't have the capacity to manufacture medicines, how they are going to deal with the situation and public health pandemics. So, our discussion is mostly on the intellectual property versus access to medicines. So, this is the basic discussion. So, the question is whether intellectual property protection affects the supply of medicines, because the medicines are covered under the intellectual property regime. The medicines are patented. So, due to the patenting and the monopoly which is granted for 20 years, whether it is affecting the prices. So, the main allegation against the pharmaceutical companies is that they are exorbitantly charging the medicines, especially the essential medicines, those who are going to affect or to deal with the pandemics. So, the IPR, everybody knows that is an incentive for innovation on one hand, and second, in order to maintain the public health, that is also very important. So, the innovation, patenting encourages people to come out with new medicines for new diseases, and also yes, new medicines are required to deal with the new diseases. At the same time, the patenting, whether it is becoming an obstruction to the maintenance of public health, that is a question. So, selling these particular products, and the whole issue is focused on the prices of patented medicines and the prices of generic medicines. So, most of the developing countries are dependent on generic medicines, because the patented medicines are costly, very costly, which so the affordability question comes. The affordability is again a discussion point. So, in 2001 itself, what the WTO, the Doha Declaration, what they did? They discussed this particular problem, the problem of pandemic, the pandemics, and the problem of non-affordability, and the problem of countries, those who doesn't have manufacturing capacities. And the WTO members was of the unanimous opinion that every country have the freedom to deal with public health problems affecting their own countries, especially developing countries. So, the Doha Declaration on Public Health specifically identifies certain options and which gives certain options to the developing countries to deal with this particular problem. And here the November 14th declaration in 2001, which talks about and it says that the TRIPS agreement does not and should not prevent members from taking measures to protect public health. It declares that the TRIPS agreement is not an obstacle or a barrier for maintaining public health at the member countries. So, every member have a right to grant compulsory licenses and to determine the freedom of license. So, which is already there in the TRIPS agreement. And also the Doha Declaration gave what constitutes a national emergency or other circumstance of extreme urgency. So, it depends upon the circumstances in each member country. So, basically every member country can decide what constitutes a health crisis. So, the old pandemics like HIV/AIDS, tuberculosis, malaria and the new diseases or pandemics like COVID-19. So, it is up to the member countries to decide what constitutes a national emergency or extreme urgency. So, and this is the Doha the provisions, and also the Doha Declaration reaffirms the need for Article 7 of the TRIPS agreement, the technology transfer, and Article 66(2) of the Doha Declaration says we reaffirm the commitment of developed country members to provide incentives to their enterprises and institutions to promote and encourage technology transfer to least developed country members pursuant to Article 66(2). So, the declaration urges the developed countries to transfer the technologies to least developed countries and other countries, including the medicines. And the Doha Declaration allows parallel importation. What do you mean by parallel importation? This is the importation of goods without the consent of the patent holder of a particular patented product marketed in another country. So, it means you import this particular product from another country even though that particular product is patented and there is no need of consent of the patent holder to import that particular product from another country. So, patent holder's consent is not required. So, parallel importation is permitted. So, if a particular medicine is in another market, you can purchase it for a lower prices from that market and transport it to your country. So, the patent holder's consent is not required. And secondly, the Doha Declaration very clearly says the principle of exhaustion will be applicable. What is this principle of exhaustion? It says that the patent holder once sold a particular product, a patented product, and he cannot prohibit subsequent resales of that product. His rights are exhausted with the first sale. And also is exhausted by the act of selling that particular product. So, this is the principle of exhaustion. So, once the product is sold, he do not have any right over the product and he cannot enforce his patent rights over that particular product. And again it says that parallel importation cannot be challenged under the WTO dispute settlement system. So, the Doha Declaration made it very clear that the parallel importation cannot be questioned. It is not a violation of WTO agreement. And also, and the Doha Declaration confirms each member to have their own regime for such exhaustion without challenge. So, they can add provisions in their own domestic law to implement these particular provisions. And parallel importation is considered to be one of the essential tool enabling access to or affordable to medicines, because you can import these particular medicines which are not available in your market from other markets. And there can be price difference, there can be definitely there is substantial price differences between markets, and the same pharmaceutical company is selling the medicine not for the same price all over the world. So, what you can do? You can go to the world market wherever the prices of this particular medicine is the lowest, and they can purchase and import into your own country. So, this is the parallel importation. So, parallel importation is allowed under the Doha Declaration, and which the patent holder cannot question. So, if we closely look into what exactly the Doha Declaration provides for, and the Doha Declaration provides for access to medicines, and especially the medicines to treat pandemics, even including. So, we will come back to the Doha, the COVID-19 later, the situation, but the COVID-19 situation was foreseen by the WTO members in 2001 itself, and that is why in 2001 itself there was this Doha Declaration on public health, which clearly says that the TRIPS agreement should not be an obstacle to take policies balance between intellectual property rights and access to medicines. So, public health maintenance should be given primacy or importance over the patent intellectual property protection. So, intellectual property is also important, at the same time access to medicines also is important, and the most importantly the Doha Declaration activated the compulsory licensing provision. So, every members have right to issue compulsory licenses based on certain grounds. So, it means it is very simple, you compulsory license a particular patented medicines and produce it at your own facilities. So, patent holders consent is not required, but you have to pay royalties. So, affordable medicines, its objective is very clear, to supply affordable medicines to the people, those who want it. Then another one is, the point is which we discussed, is the parallel importation. Parallel importation is allowed to import cheaper medicines and affordability and availability. So, the Doha Declaration very clearly emphasis on availability and affordability of pharmaceutical medicines. It talks about especially essential medicines, and also it talks about the cooperation between developed countries and developing countries, private sector and public sector, in order to maintain a parity between these sectors, and also to help the least developed countries as well. And Doha Declaration again talks about non-discrimination principle once again, even though it is a part of the WTO agreement, and it says that countries to avoid measures that would disproportionately affect the trade of countries with insufficient or no manufacturing capacities in the pharmaceutical sector. So, you can see that immediately after the 2003 decision with regard to implement the Doha Declaration on the countries those who does not have the manufacturing capacity, that decision allows the countries those who does not have the manufacturing capacity, you can issue a license to a country where those who have manufacturing facility. So, it means if Nepal does not have a manufacturing facility, they can issue a compulsory licenses in the name of India, and India can manufacture this particular medicine and transport it back to the Nepal. So, this the special mechanism is provided to the countries those who does not have the manufacturing capacity of medicines. So, the Doha Declaration results are very clear and evident that this is to protect the public health sectors of especially the developing and least developed countries, and the TRIPS agreement should not become a hindrance to the maintenance of public health and also access to medicines. That is a very important point which is put forward by the Doha Development Agenda, and also it clearly talks about striking a balance between protecting innovation, protecting intellectual property, and the urgent health need of countries, especially developing countries, to meet with pandemics. And I was talking about the 2003 General Council decision, and the decision 2001 Doha Declaration and 2003 Doha Declaration was implemented through this particular decision, especially with regard to the countries those who have insufficient or no manufacturing capacities in the pharmaceutical sector. So, and as I told you, it is very simple, they can issue a compulsory license to a country, those who have manufacturing capacity, and this is to be informed to the TRIPS Council of such production of medicines. So, and also we can see that the TRIPS provisions are amended in 2005 accordingly. So, and these changes are approved by countries. So, the various decisions up to 2013 has the extend the deadlines, the approvals and acceptance was extended from time to time even up to 2015 to deal with this 2003 decision. And you can see the countries those who have approved the amendment. There are so many countries those who have approved the amendment, and India approved the amendment in 26th March 2007. So, even though it took a long period of time, but most of the countries are approved in 2007, and later on in 2011, 2012, 2013. So, most of the countries are approved during this particular period 2009 to 2013. So, it become a law in most of the countries, and India also implemented this particular decision at the domestic level. And then compulsory licensing. Compulsory licensing is always a contentious issue between developed countries and developing countries. So, what kind of compulsory licensing can be issued, or when the compulsory licensing can be issued, and this is a contentious issue. So, you can see the first notification under the Doha Declaration came in 2007 itself. So, under the compulsory licensing, Rwanda is unable to make this particular cheaper medicine, generic medicines. So, fixed dose combinations of pseudovidin and lamivudine and nevirapine. This is basically, these medicines are for treating the AIDS pandemic. So, Rwanda has issued a compulsory licensing to manufacture these particular medicines. And in 2007, you can see that Canada, the first notification. So, the first notification to medicine a generic version of a patented medicine for export under the 2003 regime, and this is also mainly for treating the AIDS pandemic. So, as I told you, if Rwanda does not have a manufacturing facility, you can ask other countries to make it, and Canada made it and sent it back to Rwanda. And other countries announced, 23 countries, around 23 countries announced that, including Hong Kong, China and other countries, they are not going to avail the 2003 facility. It means that they declared that they are not going to issue any compulsory licenses in accordance with 2003 decision. And even interesting to see that the China is also there in the list of countries, those who are not going to issue compulsory license, they declared. So, you can see Many countries amended their domestic law according to the decision to facilitate manufacturing of these particular medicines. And also the facilities, compulsory licensing is always, I told you that it is a contentious issue between the developed countries and developing countries, or I would say that the countries those who have the patented medicines and countries those who produces generic medicines like India. So, this compulsory license, special compulsory license can be issued only for public health purposes, and a reasonable royalty has to be paid to the patent holder. So, we can see that the compulsory licensing criteria like public welfare and not working in the country, not working in the country of registration, and the exploitation and improvement of inventions. So, public welfare is a provision in many countries, but in most of the countries non-working is not a ground for compulsory licensing. Improvement exploitation is also a provision in some of the countries like China and Japan, but not in India. So, criteria for compulsory licensing is commonly placed in the TRIPS agreement, but its usage is very less among the member countries. And when you take the Indian case, India issued the first compulsory licensing in 2012, and this compulsory licensing was granted to a domestic pharmaceutical company, Natco Pharma. So, this compulsory license was issued in order to make a generic version of sorafenib. So, this is basically, you can see that which was against. This is the first compulsory license to manufacture a generic version of a patented medicines. And if you look into the prices of these sorafenib is very high. So, Bayer supplied only drug to only to 2% of the patients of the population. So, the patented drug Nexavar. So, and at the same the price also we have to look into 2.8 lakh rupees for a month supply for a patient. This is highly unaffordable for the common people in India. So, but even though the Bayer has claimed that it is reasonably affordable, but 2.8 lakh rupees per month, we as a common Indian, we know that it is not is affordable. So, we know that it is exorbitantly priced. And third reason India has shown is that Bayer did not sufficiently work the patent in India, non-working of the patent. So, one is affordability. So, its supply is very less. 2, exorbitant prices. 3, non-working of the patent. India invoked all these particular grounds, and definitely the Bayer has gone on appeal. At that point of time, the Intellectual Property Appellate Board was the appellate authority, and that was confirmed by the appellate authority at that point of time, and now the Intellectual Property Appellate Board is abolished, and the high courts are dealing with these kind of appeals. So, the first compulsory licensing was granted to Natco Pharma, and the cost from 2.8 lakhs to 8,800 rupees. So, the prices has gone drastically down, many percentages down, and the medicine was made affordable to the common people for 8,800 rupees. So, that means $5,000 to $160 per month. So, this was a drastic changes all over the world, and many countries thought of compulsory licensing these unaffordable prices. So, affordability is one of the grounds, access is another ground, and the royalty payments to be made, and even the the IPAB has increased the royalty payment from 6% to 7%, and one of the highest in the world ever paid as royalty for any compulsory licensing. And in many countries gone ahead. In some of the cases, there is more number of applications in India itself which was rejected by the Controller General of Patents in India. So, other countries also has come up with similar. So, we can see some of the patent cases as well as came to the TRIPS agreement, under the TRIPS agreement with regard to medicines. So, we can see that around 14 cases came to the WTO on TRIPS agreement. So, Doha Declaration was a path-breaking decision in 2001 to deal with pandemics. Affordability. So, many countries were facing affordability and access to medicines. So, the patented medicines should not exploit the market against the health needs of each and every country. So, developing countries and developed countries also has to have laws in order to maintain the drugs prices. And most importantly, the patented medicines cannot be used as a tool for economic exploitation. So, the innovations to be made for public good. Even though there was a provision in the TRIPS agreement for compulsory licensing, most of the countries were not utilizing it. This is mainly due to the pressure from the developed countries and the multinational pharmaceutical companies, those who have these patents, those who have patented medicines. And the Doha Declaration, which reiterates the importance of intellectual property protection, especially for developing countries and countries those who doesn't have the manufacturing capacity. Even during the COVID time, the COVID-19 time, and there was many discussions to amend again the TRIPS agreement to the access to the vaccines. So, the pandemics will come again and again. So, the patent should not be, the intellectual property should not be a barrier for protecting public health of, I would say that, the people of developed as well as developing countries. So, Doha Declaration is very important in future as well. So, we will stop here with the module of TRIPS agreement. Thank you.